Hello guys, welcome to this video. Today we are going to look at an important case law in certiorari. Certiorari is the modern quashing order. So the case that we're going to look at is the case of Medical Appeal Tribunal ex parte Gilmore that took place in 1957. So in this case, Lord Denning stated thus that the remedy of certiorari is never to be taken away by any statute except by the most clear and explicit words. The word final is not enough. That means without appeal. It does not mean without recourse to certiorari. It makes the decision final on the facts but not on the law, notwithstanding that the decision is by a statute made final. Certiorari can still issue for excess jurisdiction or for error on the face of the record. If tribunals were to be at the liberty to exceed their jurisdiction without any checks by the courts, the rule of law would be at an end. So by extrapolation, this rule of Lord Denning would apply to mandamus and prohibition orders. Let us look at the more intricate details of the case of Medical Appeal Tribunal ex parte Gilmore in 1957. So we begin. Robert Gilmore applied for an order of certiorari to remove a decision of a medical appeal tribunal in order to quash it. The decision concerned the correct application of Regulation 25 of the National Insurance Regulations of 1948, which dealt with an injury to one or two paired organs such as eyes or legs. If a person with two good eyes lost sight of one of them in an industrial accident, their disablement was assessed at 30%, but their disablement benefit was assessed at 100%. Robert Gilmore was injured in both eyes by lime burns 20 years ago and appealed to the Medical Appeal Tribunal, who held that the case did not come within the provision for review. Mr. Gilmore appeared to the Queen's Court. So the issue here is whether the court has jurisdiction to issue certiorari to quash the decision of the Medical Appeal Tribunal for error of law on the face of the record, despite the fact that the decision is made final by statute. So the decision here is that the court has jurisdiction to issue a certiorari to quash the decision of the Medical Appeal Tribunal for error of law on the face of the record, despite the fact that the decision is made final by statute. The order must issue to quash the declaration of the Medical Appeal Tribunal of 13th June 1956. So the reasoning is Parliament only gives the impress of finality to the decisions of the tribunal on the condition that they are reached in accordance with the law. The court has always had power to order an inferior tribunal to complete the record, making the decision final on facts but not final on the law. The court can issue a certiorari to quash a decision for excess jurisdiction or error of law on the face of the record, unless the remedy is expressly taken away by an act of Parliament. The statement that the decision shall be final is not sufficient to oust the remedy. The court has jurisdiction to grant the order and it should be made. No question of discretion arises since the applicant is clearly a party aggrieved. So in this case, we find the importance of courts being able to issue any of the 3 remedies when matters that need them arise. Thank you for watching this video. Like, share and subscribe.